certain elements of such a regulatory authority that, to me, are necessary for it to be functional. First of all, the authority must be independent. So it cannot be subject to any department or any politician or any company or any business, political or other interest. It must be an independent authority. Dr. Byra spoke about pillars on which the problems rest that we are talking. And if we think of departments of the national government, there's the Department of Health, and we think of that as a pillar. And then there's the Department of Justice as another pillar, but there's a space between them. And then there's the Department of Transport, another pillar. And then there's the Department of Social Services. You will notice that everything we've been talking about is in some way related to one or more of those departments. And of course, the one that I haven't mentioned is National Treasury, because whatever happens has to be funded. So there are in reality 5 pillars. Pillars of the existing government, which are relevant to the ills, the crisis, the harm, the damage that pervades the medico-legal fraternity. In the medico-legal arena, and Brad asked me last night, what is the medico-legal? What is the definition of medico-legal? Who is a medico-legal practitioner? Where is that definition recorded? Well, we have a South African Medico-Legal Association. We think we know what it is, but we don't actually put it into words as a definition. So what we mean when we say a medico-legal, we mean things that happen where lawyers and doctors and other healthcare experts are involved in either dealing with those problems, solving those problems, or fighting about those problems. But in that broad arena, the one thing that, whichever way we look at it from, the one thing that is a reality is the incredible amount of human suffering. So disability, Alison showed us some pictures, and many of us cried. We don't every day look at disability. We don't think about it. We rather turn a blind eye. We like to sweep it under the carpet. But the people who live with disability and the people who look after those with disability have a very hard time. There is tremendous human suffering in every disabled person, and there's suffering in those who look after the disabled person and also in those who interact with a disabled person. I know that when I interview a patient who is depressed, I get depressed. So I know my patient is depressed because I feel sad. When I walk into an old age home or a frail care center, I feel depressed. And I'm not responsible, I'm not in charge, but it just has an effect on me. And I've been working with neurological disability and injuries and death for most of my professional career. In addition to that human suffering, which is very hard to quantify, but it is part of being human, it is important to recognize it. In addition to that, there is the loss of economic productivity, because every disabled person doesn't contribute to the economy. And everybody who looks after a disabled person also doesn't otherwise contribute to the economy. So the drain on the economy of a person with disability is serious. And when we are talking about the number of crashes on the roads, the deaths are the dramatic thing that we all like to see in the paper, and the minister reports them after the weekend and so and so and so. But the people who die get buried, and people cry, and they get over it, and they get back to work. But for everybody with a serious injury, it is an ongoing long-term drain. So the loss of economic productivity, if we think about the numbers of road deaths, far greater than that is the number of road injuries, which leads to permanent disability of various degrees. We don't know what that is worth in money terms. I haven't come across an actuary or a government department who has quantified the cost to the economy of the loss of productivity associated with road accidents, or the loss of productivity associated with clinical negligence. So we don't know about it, so maybe we needn't bother about it. What we do know is the money that people actually owe, and that is staggering. So we heard today the statistics about the health department's contingent liability. If all of those cases go to court, if all of them are found to have merits, and if courts award all the amounts that are claimed, it will be over 90 billion rand. The health department hopes, and I think they are correct, it will be less than that because some of the cases will be without merit, some of the claims will be inflated and they will be awarded at lower amounts. And we don't know what that is, but that is a staggering amount of money, and it can be counted in money. We heard that the road accident fund debt, or deficit, Lusani, what do we call it? The liability is over 200 billion rand. So the directly measurable money problem in the medico-legal field in South Africa today, from two causes, road accidents and state negligence, state health negligence, is 300 billion rand. I don't know, and I don't know if anybody else knows, how much contingent liability is there for negligence in the private sector, because who would know that figure? So we are talking about a massive and a very serious problem. We also heard, and all of us know, that whatever the causes are that feed into those problems are inflated by constrained resources. They are also, unfortunately, inflated by maladministration. Professor van der Heever spoke a lot about that. They are inflated and in some cases caused by unprofessional conduct. And many of them are caused by frank negligence. And the whole thing is made worse by corruption. I've heard horrifying stories about attorneys appointed by the Road Accident Fund who get a whole number of thousand files for relatively trivial injuries, and to keep the files open until, on average, each file has generated 150,000 rands worth of costs. And it was not necessary to get anywhere near to there, but that's the system. And how it is permitted is because they're in collusion with whoever is giving them the contract from the Road Accident Fund. I've also been horrified to hear how the collusion between plaintiff and defendant attorneys in, on the one hand, fabricating false claims, on the other hand, grossly exaggerating claims, and everybody shares a little bit of the excess wealth. So these problems are really serious. It is because we all know that they are serious that this brain's trust of people from around South Africa came together today to address President Ramaphosa on what can we do about this problem. Now, we've heard a lot of suggestions, a lot of proposals from people in a lot of different disciplines. I don't think the President will be able to refer this matter to one department or another department or another department or whatever to solve, because the problem involves 5 state departments. But to me, the bigger problem than that is the gaps in between those departments. To give you a little example, the Road Accident Fund Amendment Act specifies that for general damage awards, injuries have to be regarded as serious. Now that the regulations promulgated under that Act are promulgated by the Minister of Transport. But what are the implications of those regulations? They prescribe what doctors must do. Doctors do not resort under the Ministry of Transport. And they prescribe what lawyers must do. And they take away rights from courts. So the Department of Transport is prescribing the conduct of medical practitioners, legal practitioners, and courts. Now, that cannot possibly be in the remit or the competence of the Minister of Transport. And by the Minister, I don't mean a person, I mean the office. Because it involves the gap between different departments. We are talking about the problem that when a court determines that negligence by a hospital or midwives or obstetricians was responsible for cerebral palsy, and the court awards, according to the law of delict, an amount of money to compensate for the harm that was caused unlawfully, that the Department of Health has to pay that money, but they must take it from medicine money or X-ray machine maintenance money. They can't take it from a fund designed to cover them for the risk of malpractice. Why that is so really boggles my mind, but luckily I don't understand finance or governance, so I needn't understand that, but it still boggles my mind. And I see the Director General of the Department of Health nodding in agreement at this point. Now, that problem is an issue between health and justice and treasury. So it is a gap problem. And as I see it, if we think of these 5 pillars and a platform on top, and the platform is thin, and there are huge gaps, and there's a huge weight of trouble going on, the platform sinks in and it's dysfunctional and it gives way in the gaps more than where the pillars are. And that is the problem that I really want us to address. It is a proposal that if the President were to acknowledge the seriousness of this problem and the need in the national interest, and most particularly the interests of vulnerable members of society, to address this problem head on. The logical first step would be to establish an independent, multidisciplinary regulatory authority to take responsibility for medico-legal practice and everything of whatever ilk that falls under the ambit of medico-legal practice. So it cannot belong to one department. It must, on the one hand, be staffed by people from all disciplines that are relevant. It can include members of each of those pillars departments because of the way it affects them. But the most important thing for such an authority to be functional, apart from which disciplines congregate there and where the authority comes from, will be the moral authority of the people who are entrusted with that responsibility. A system like that cannot work if people are put there because they had a rough time previously and now they're being rewarded with a nice job and a nice salary. It won't work. The crucial requirements are people that are suitably qualified, suitably experienced, but maybe more important than qualification and experience is people who have got a good track record of being recognized and respected by their peers as being upstanding members of society that people can look up to and respect. I said it in a small way earlier this morning. I look to the Office of Health Standards Compliance as an example of how to achieve that kind of structure. So that is my wish. That is what I would like to be established. And I would now like to turn to the panel for opinions for or against, and for everybody who is for to say something constructive about how we can achieve that. So I'd like to start with Professor Stellenberg.
I was asked to think about it. I wasn't prepared for the chair. Well, it would be a good thing to have a regulating body to manage this, because it is a fact that these issues cut across five. Now we've identified the Treasury as the fifth pillar. And starting with the patient from the time they're admitted into the hospital, that's the health issue. It moves from there. Possibly if there's an adverse event, it goes to the judiciary, and they're involved. Transport, if it's the RAF. And then there's still the Treasury, because now it's about funding as well. But there's the social part of it, is that Social Security has to come in, finally, because it's a long-term situation. And it is a fact that there are many out there that are fly-by-nights. There are people out there that are enriching themselves with the system. You know, there's an adverse event, people even lobby for adverse events, you know. Tell us, you listen to it on the radio. Cape Town, they have a particular a firm of attorneys who advertise that says, you know, that just tell us if something went wrong in the hospital, we'll get to you, sorting it out for you. You know, so, and it will allow us also to look at the upstream issues, to prevent problems within the clinical environments. I mentioned this morning something, you know, which is very fresh from research that we've just completed, that I found no statistical difference between what's happening in the private sector and in the public sector. There's much more, because I've done research in the private sector, and we've just completed the public sector, and we'll be putting them all together. So I am absolutely for that we have such a regulating body that would set standards. It would be the office of the Medico-Legal, as it's whatever name we're going to give it, but that there would be very specific standards, and it would be multidisciplinary approach. And I agree with Herman, is that we need people with outstanding morals, you know, and ethics that would be on that type of, and also experienced and know what they are doing, expertise. Thank you.
While Dr. Lerm is making his way here, I just want to tell you, yesterday we were involved in one of our postgraduate medico-legal training workshops, which is a SOMLA UCT combined event in this same venue, and we had other participants in Cape Town and others online in various parts of the country. There were 126 people in the workshop yesterday. The workshop topic was emotional shock, psychological consequences of injuries, and constitutional damages. And everybody had done a task, an assignment, and everybody had been to a syndicate meeting, and yesterday was the concluding day with report back and debate from all the syndicates. It was a magnificent day because everybody was talking about ethics. It was about psychology and constitutional damages, but every syndicate came back talking about ethics. Towards the end of the day, I preempted this debate and mentioned briefly that we were going to be talking about this today, and just asked for a snap opinion from everybody there. 100% of those at the workshop supported and applauded the idea of effective regulatory authority. Dr. Lerm?
Thank you. So I'll answer one question that Herman raised earlier about a possible definition for the term medico-legal practitioner. And I gave it some thought, and it's very crudely put at this stage, and we can refine the definition, but I thought it is an amalgam of medical and legal practitioners who pool their expertise, knowledge, and experience, and who go about their task in an independent, objective, and unbiased manner within their areas of expertise in furthering the cause of justice in both litigation and mediation. I have been persuaded after I formulated this crude definition that we should perhaps change the term medical to healthcare practitioners. And I'm persuaded by that, because we don't only include clinical practitioners, but what about your psychologists, psychiatrists, et cetera, as well? So I'm prepared to revisit that and perhaps change that and align that with healthcare practitioners. That's the first point I wish to make. Whilst I was sitting here listening very attentively to the speakers, I contacted my friend Google, and I wanted to get an idea of what does a multidisciplinary regulatory authority, what does it mean? I came across a definition. I'm not suggesting for 1 minute this should be adopted, but it could lead us to a discussion on certain of the elements that's included in there. And I quote, a regulatory authority is a public authority or a government agency responsible for exercising autonomous authority over some area of human activity in a regulatory or supervisory capacity. And then it goes on, it must be an independent regulatory agency. It's a regulatory agency that is independent from other areas of government. So either one has to pursue this in the form of a public authority or a government agency. Now, Herman alluded us to certain principles, etc., etc. I just want to touch on one particular aspect, if I may. I think in both instances, whether it is a public authority or government agency, I believe that the issue that we need to ask ourselves, where would this agency or government authority derive its regulatory authority from? And I'm going to submit with respect, there must be a statute that introduces that particular multidisciplinary regulatory authority. Who will make or be instrumental to introducing that in a form of a statute? It could be the Minister of Justice, could be the Minister of Health. So I thought I'd make that particular point that's very important. I'm supportive of the idea of a multidisciplinary authority. And I promote the idea as well that whoever falls under this particular authority, call it medico-legal practitioners or healthcare legal practitioners, they should be regulated by a code of conduct. And in the code of conduct, one would then spell out what is the purpose of the code, what disciplinary measures would be introduced if someone transgresses, how to deal with members who do not toe the line, so to speak, etc., etc. I'm glad to say that at this stage, and I think Herman alluded us earlier to the fact that we almost in a third draft now, drafting a code for SAMBLA members. And we spoke about it last night around the table. I'm sure that if it is accepted by our board, that if there is a authority, as we are talking about, that we envisage that will come into being, they could perhaps mimic some of the principles that we have incorporated in the third draft, and I'm sure it will be accepted, this code of conduct in the end. But it's just to conclude, I think it's very important that there has to be a code of conduct regulating the practitioners who will fall under this regulatory authority. Thank you.
As Lusani is on his way to the podium, I just want to go to what Dr. Lerm said, possibly the Minister of Justice, possibly the Minister of Health. Is it not more sensible, because this spans 5 ministries and huge gaps in between those ministries, that this should come from the Office of the Presidency? Lusani?
Thank you. Obviously, I think the issue at hand is less of an actuarial issue, but it does also touch on our professionalism, which is important to what we do. I would also say yes to this, because there are many issues where you are not sure who should be taking the lead. They fall through the cracks. Not just in terms of departments, but between us. Is it the lawyers? Is it the medical experts? Because you find that the lawyers would be the ones that are hiring the rest of us, and they give us briefs of what to do. And in terms of our professional responsibility, I mean, we cannot go beyond those briefs. So we then are limited. So one of the things that such a body would, I'm not sure whether that's one of the things that they would need to look into is the scope of practice of the different professions, the disciplines, and perhaps one of the things to look at. And I think obviously the devil is in the detail. I think it's a kind of instrument that can become like a two-edged sword in a sense. It can be used for harm, but if it's put together properly, it can then be used for good. So I think getting to the detail will be a very important process. And I want to think, on the back of the discussion that we've had about medical negligence, where I commented that everyone sounded very level-headed. Because, coming to these type of things, one is very skeptical. One is very skeptical that there's a conflict of interest, self-interest. So one needs an assurance upfront that is not going to be the case with this kind of thing. It's not people wanting to protect their turfs or something like that. I mean, I don't know how you're going to give that undertaking, but it needs to be very clear that we're not here to protect any interests. And one of the things that I've thought about in terms of using the current term medico-legal aspect is that I wonder to what extent sometimes you sort of cannibalizing on what you're actually supposed to do, in a sense that as a business, as an individual, you begin to just focus only on this, and you want every problem. You basically turn every problem into a medico-legal problem. Whereas sometimes you have to be treating the people and not arguing about it. But I think that will be covered. I'm just putting some of the issues that could be of concern. And then there's the issue of research as well. There's a lot of research needed. I think at times we don't have the accurate numbers, and no one is going to sponsor that research. I would want to think that this is one of the things that would need to be looked at, this body, to sponsor some of the research that is required. Thank you very much.
I have to leave now, sorry, because my flight is going to leave at 4. I just want to thank you for a fantastic meeting, and it was really great. I think we all learned a lot from this meeting. The one thing I wanted to add is that I absolutely agree we need this independent regulatory body, but from a practical sense, I think where we should start is that we should have a kind of committee of high-level experts that are drawn from all the disciplines that can serve as a gatekeeper to these adverse events.
Yes.
So they can kind of decide whether this is a frivolous or vexatious claim, yes, or it's true or whatever. I know in Singapore and Australia and in Ireland, they have this kind of stuff, where they have this high-level committee when adverse events goes there, and then the committee will then decide on whether it's vexatious or whether there's merit or whatever. And I think that's a starting point. And after that case can then go wherever it needs to go. But if that committee doesn't have legal teeth, and whatever it is, in whatever form it takes, it's never going to work. Because the attorneys and lawyers and plaintiff lawyers or whatever, or any lawyer is going to say, no, but that doesn't work. I'm going to do my own thing or whatever. So I think from a practical sense, I think where this discussion should go is how do we develop and form a committee of high-level experts that can serve as a gatekeeper to adverse events that are occurring in the whole country. And that is
Thank you.
comment.
Thank you very much, Dr. Borat, and thank you for your personal contribution to today's meeting. And I hope that your mind is going to be available for future developments of this. Can we carry on, Ashley?
Yes. We can perhaps just, maybe just to answer the is that the Office of Health Standards has an early warning system that's going to be introduced. And electronically, all health establishments must inform the office about things that are very serious, that happens within 24 hours, and then monthly, all adverse events. So that is going to be introduced soon.
Thank you very much.
Okay, they have to report to the regulator.
Yeah, but I'm talking about a high-level committee that will look at human custody evidence and say whether this is a frivolous case, it's a case, or whether this case is not fine.
Well, those are the early warning system that's going to be introduced for
Professor
adverse
van der
events.
Heever?
Yeah, I just want to answer before we've got a name. We've got a name that we thought of, the healthcare public protector for healthcare legal professionals compliance.
Thank
Something
you.
like that.
Thank you. You see, there you can think, Ethelwynn. Thank you.
Just,
Professor van der Heever?
yeah, it's just to kind of make a distinction between different kinds of problems when solving. I think the problem, if you look at those cases that were presented to us, there's the distance, the gap between when a case is kind of arises and when the claim comes through. So there's a gap in treatment and protection for that person. There is the issue that there are people who are not cerebral palsy cases because of medical negligence who don't get any treatment. And then there is an issue about frivolous cases. So the one issue is protect the people who need access to care first, and that system has to be designed. And what we've got is a case where we've got very substantial legal payments coming through at the end, payouts coming at the end of the day to somebody who's been damaged by the delay. So you've got the worst of all possible worlds, even for the person who's been a recipient of pay. This is not a proper system.
No. Thank you very much. Leader Souza? Sorry, Henry? Yes, please come here. Henry and Leigh, both come here. Please, Henry.
As far as the assessment of frivolous claims or not, with respect, I think that should come at a very early stage. That should be monitored in the health department of the provinces, where you establish a unit comprising of medical experts as well as lawyers who sit there, look at the cases, see if there are merits in those cases or not, then decide what they're going to do. Are they going to advise the attorneys then accordingly that you've got no claim? There are consequences if you pursue this particular matter. We're going to ask for cost orders against you as an attorney. Or if there are merits in this particular case, then early settlements that follow. This regulatory body that is envisaged here will deal with any transgressions also more on that particular line, not investigating as such whether they're frivolous claims or not.
I'll try and be brief. The one thing that has been raised, and I think it's important all round, is access to treatment and early access to treatment. Kathy Satchwell set it out in her commission back in 2002. She spoke about the golden hour of treatment, something which is not happening. So any sort of committee that would be capable of possibly speeding up processes, I'm all for. I think a regulatory body is essential. On a practical level, we sit as attorneys being advised by medico-legal experts. I can tell you now, on many cases, if you read my set of reports and you read the defendant's set of reports, you would find it difficult to believe that they're reporting on the same person. Not always, but often. And I think to a great extent there are hired guns being used, not always. And I ask the two very competent, defendant-orientated attorneys and advocates sitting there, don't judge the manner in which you run your matters, or don't judge other attorneys, because they don't run the matters the way you do. So there's fault all round. I think we all know there are plaintiff attorneys who do wrong, there are defendant attorneys who do wrong, and there are medico-legal experts who don't act the way they should. So I think that does need to be addressed. The collusion that someone spoke about has come through in the courts. We have a situation where the courts currently are descending into the arena. We had a matter the other day in court where the parties had reached settlements, and the court jumped in and said, oh, no, I'm not happy with that settlement. It's not the role of the court. The court currently, I feel, is painting everyone with the same brush. They feel that if there is collusion, they need to stamp it out, but they need to deal with it on a case-by-case basis. At the moment, that's not happening. So yes, I'm in favour of a regulatory body. I don't think it can be a voluntary association at all. It was said it needs to have teeth. So yeah, I'm all in favour.
Thank you, Leigh. Sharon?
Okay, all in favour as well. For me, I think the critical thing is around the locus of control. So it's fantastic to have a multidisciplinary team, but if you've got no power, what are you actually going to do? And how are we holding each other accountable as peers? So I think it has to have different people, not just healthcare practitioners, but also the people who are experiencing it. Because for me, listening to Alison's story, connected at a much deeper level than just at a head level of, oh, okay, so this is the matter, these are the merits, but to actually hear the real story. So I think it's important to incorporate the different voices and actually have the power to make a difference. And I think for all of us here, we're all enraged. We want the medical crisis to end. So we mustn't underestimate the power of a small group of people who are committed to the same cause. Thank you.
Thank you. Trevor, will you come forward? I just want to address one small point. Lusani has unfortunately left, but remember he was saying that the thing must not be populated by people serving their personal or sectoral or professional or commercial interests. That is what we meant broadly by people of high moral authority. The question that is raised is how do you identify people of high moral authority? There are certain ways. I believe that people like Professor van der Heever and Dr. Beyer know much better than I do how to achieve that. But the one thing is whether they have any actual interest in the outcomes of the issue. So a person who's got an interest may be honest or dishonest. A person who doesn't have an interest is less likely to be biased. The other thing is a person's track record. And there's another thing. If you listen to what a lot of people said today, they gave advice in the interests of the population and in the interests of the government, in the interests of the national fiscus. A lot of their recommendations were contrary to their own professional interest.
Firstly, thank the meeting for allowing me to participate at risk, of course. But just to say that I want to quote the former Secretary of Health of the UK, Frank Dobson, who said he would like to take lawyers out of hospitals and doctors out of courts. And I take it that this process is intended to do just that.
Exactly.
And
Dr. Matoso, you may remember in March 2015,
yes,
where I met you at the summit, it was stated in that summit that if doctors don't commit negligent acts, there'll be no place for lawyers in the lives of doctors or in hospitals.
yes. So I'm just quoting that again, the words of Frank Dobson. But also to say that if you allow me, I will share the draft National Health Litigation Authority Bill that was drafted a while ago with the assistance of the CEO of the National Health Litigation Authority of the NHS in the UK, who has since retired. But
whatever regulatory authority is created must not usurp the role of anyone that is existing currently. Those currently existing regulatory authorities should be strengthened if they are not working, supported where they can be supported, but where they do not meet the need of the medico-legal expertise, that a new structure then be put in place. That structure must have teeth is obvious, otherwise it would serve no purpose. I want to emphasize the moral authority of the people who serve on that. I believe that one of the shortcomings that we in the health professions face is that some years ago the decision was taken that professional board representatives would not be elected by the healthcare professions to the board that was applicable, but they would be nominated by the Minister of Health. And I believe that over time, if we look back, I think that certainly in the eyes of the practitioners, those boards lost a lot of credibility because they were not staffed by people who had the stature to do the job and had the gravitas among the community. A point was made about a voluntary association not being a regulatory authority. I can't support that any more strongly. I think there are two fundamentally different functions that are served. I want to use the example of the South African Clinical Neuropsychology Association just to highlight that. Many years ago, it was recognized that neuropsychology did not have a place in the current legislation. And because of that, a voluntary association was created that tried to, on the one hand, formalize clinical neuropsychology as a discipline that should resort under the Professional Board for Psychology, but on the other hand, serve to protect the users of clinical neuropsychological services. At that time, there were a host of people allegedly providing those services, and the quality of services were not always enforced or maintained. The Neuropsychology Association then became a voluntary association, a peer credentialing association that examined its members, those who volunteered to submit themselves to examination, and in doing so, showing that they are competent and they subscribe to the values. The difficulty with that is that it never progressed further than that, despite New York in place, that governs the behavior of clinical neuropsychologists. At present, what happens is that behavior is governed by the voluntary association, and the strongest sanction is to say, well, we don't want you as a member, and we suspend your membership or terminate your membership, which in many ways has absolutely no teeth. I think those are the critical issues for me around the regulatory authority. Certainly, I believe that there has to be a regulatory authority. There are too many infringements of basic human right, too many infringements of basic human care, not to talk about loss of professionalism around this. Who this should report to, I don't think within the structure of cabinet or within the structure of the various clusters, there's one place that it can report to. And it certainly covers a multitude of things, and I think that the clever people need to advise us about that.
Are there clever people here, Trevor?
I'm sure there are. I'm not one of them.
I wish to welcome Advocate Micro Moabelo from the National Department of Health to address us on this topic. Thank you, Advocate.
Thank you very much, Chair, for giving me the opportunity and also giving the Department of Health an opportunity to be part of this very much important meeting where I think we have learned from our learned friend today about many things in medical field that I understand a little bit more. I am also happy that I'm speaking before my colleague Ronel van Zyl, because I just saw her notes. She was going to say what I'm going to say now. So you might as well just release her. The National Department of Health organized the Medico-Legal Summit in 2015 March. Some of their resolutions was that the long-term solution would be to come up with the declaration which the minister signed, and Judge Claassen and other of my colleagues in the implementation of some of the declaration. They went to the provinces, to the hospitals, met the CEOs to highlight them, to equate them with the content of those resolutions. The second most important resolution was that for the long-term solution, there must be an establishment of the National Litigation Authority, which of that long-term solution, the Department of Health, and with the help from the UK friends from the National Health Service, they have produced a National Litigation Authority bill. The bill was discussed at various forums within the Department of Health and within Justice, but it was put on hold pending the investigation for further investigation on how the authority should look like. Because even today here, I hear that you are still struggling in terms of who this authority should fall under in terms of the members of cabinet, whether it should be the Minister of Health, Transport or Social Development. But currently the bill is drafted as if it's going to be introduced by the Minister of Health. I presume that is because the resolution for the bill came from the Medico-Legal Summit in 2015. And my view is that we shouldn't worry much now about who should be the member of cabinet responsible for the authority. We should worry about how will the authority be look like. My view is also that the authority should be established not as a constitutional body but as a legislative body, meaning in terms of a national legislation that will be accountable to the minister. And the most important thing is that when the authority is established, it must be resourced, meaning it must be staffed. It shouldn't be a body that is there as a white elephant only not to perform because there's no money available for it. Then there's no need to establish a body if we're not going to fund it. That is what is much really important for us. And we support the establishment of the authority, provided that it will be capacitated, it will be resourced, so that it can render effective service to the public. Thank you very much.
Thank you very much. Professor, I'm going to give you, the debate will close with Ronel van Zyl, the researcher of the South African Law Reform Commission. So I'm going to call for questions, and whatever questions there are, Ronel, you will answer. Professor Beckett. Professor, come here. It's easier.
What I'm worried about is that we are trying to create something new, and maybe we should just, existing associations and existing bodies should be strengthened. Because, like for instance, the HPCSA. The HPCSA has a legal department, it has a medical department, it has prelims, it has all those things. Shouldn't we strengthen these different subdivisions of existing bodies? South African Medical Association has an ethical department, it has a legal department, it has all of those. And then we get to our own South African Medico-Legal Association. Shouldn't we, within the body that we have, strengthen the, our cooperative functioning, and maybe just give it some legal, strength, so that we are recognized on a wider platform by the Department of Health and so on. So do we really need a new regulatory body? Can't we just strengthen existing bodies and all these different functions that we would like to have within this new regulatory body? Can't we incorporate them into existing bodies?
Thank you very much, Professor Becker. I'm not going to give you my views on that because Ronel is going to sum up. Dr. Ensslin, Professor, will you come up here to make your comment? Dr. Ensslin.
Thank you for giving me the opportunity. I just want to make a comment on Professor Becker's suggestion, and how I see this regulatory body is not to be a slow train to Cape Town. It's there to solve a problem quickly, like a doctor who has failed to appear in court, or a claims handler who has not done his work properly, and a court case hasn't taken place. If we go through the Health Professional Council of South Africa, it'll take 5 years, and effectively it will not jackknife these people into action so that we can really, what I said this morning, have accountability. And that's how I see the purpose of this regulatory board. Thank you very much.
Thank you, Dr. Ensslin. If there's anybody else who wishes to make a comment, please come forward.
I think it's worthwhile looking at the configuration of regulators that one wants to have at the end of the day. It's not necessarily only one type. You've got to look at it kind of holistically. Regulators can be extremely useful in having sort of making a system functional without it being the actual direct deliverer of the of services. But the issue of independent regulators, so there's a general principle that needs to be established. We don't have a single independent regulator in South Africa, not one. Because the moment you have a minister or a president or a politician appointing people into that structure, into the appeal structures, into the actual boards or the councils themselves, it's no longer independent. So the Health Professions Council itself is a compromised regulator. The Pharmacy Council is compromised. The Council for Medical Schemes, which are set up, the one thing we couldn't stop when it was established was stopping ministers from appointing people into the council, and it's actually been seriously affected by that issue. So the design of structural independence, how that's achieved, is a crucial part of the designing process. How do you achieve it and still get commitment from the structure that's established? In removing conflicts of interest kind of creates a body that might actually be passive because they're not actually interested. But you can't have conflicts of interest being your animating feature. It's got to be animated by something else. So your structural independence means how are people nominated? How are people vetted? How are people then appointed? And you can separate nomination, appointment, and removal. Separate nomination, appointment, removal. They can be different bodies, different structures, multiple mechanisms for removal based on fit and proper criteria, et cetera, et cetera. So that's an issue about regulators. And then the question of location of regulators. I think that you should be locating your regulator based on where your planning platform is that supports that particular function. That's why I would oppose putting things in the presidency. The presidency doesn't have policy platforms. It's got people doing little bits of things here and there. There are no real specialist competencies and capacities. Now, departments actually do have the platforms for that. But it means that when you're creating a regulator or regulatory function, the equivalent supporting policy planning platform that's within the government department must be established that supports it, and that determines who is the minister responsible. But when that regulator is established, that minister mustn't appoint, dictate, interfere with the independent regulatory functions of that institution. If that is the case, if a minister wants to interfere in that, it's no longer a regulator. That's the fundamental issue.
Thank you very much. Well, I said I wasn't going to give my own views, but Prof, SAMLA is a voluntary organization. It's a voluntary association of professionals. It is inherently in its culture, in its nature, it is not an authoritative body. It is a voluntary association. Now, I believe that expertise in some law can inform the authority, and the authority can draw from individuals in some law if it so wishes to be there. But I don't think that it can be some law.
Okay, thank you. I'm on the fence at this stage. I'm collecting information and I'll do the research and we will come up with proposals. I do think that a body will make sense, but one will have to look at what that body is supposed to do. A regulatory body implies that that body can actually make rules and has oversight. Then you get statutory bodies which can maybe make recommendations. So you will have to decide what it is that you actually want this body to do. If you want to have some institution that can do screening, that institution can't really be judge and participant. They can't be the regulatory authority, but also do screening. That's why I'm saying it's quite important to determine what exactly do you want this body to do. I was trying to think of a quick example. I'm not aware of any of these kinds of institutions that falls directly under the Office of the President. The Office of the President has desks. They call it a desk, and it's sort of a very small function. If you take something like the now defunct Department of Women and Children and People with Disabilities, it was a desk within the presidency, and then it was elevated to a full government department, and it failed spectacularly because there was no real need for it. So there must be a need for it. There must be a political home for it. If I take the Law Reform Commission, the commissioners are appointed by the president, but we still fall under the Minister of Justice. The Legal Practitioners Act, which is now being implemented, that one is a sort of a hybrid body. Some of the members are elected by the professions, but some are appointed by the Minister of Justice, if I now remember the Act correctly. I don't have it now in front of me. All the health statutory bodies, as far as I'm aware, are all appointed by the Minister. Micro, you can confirm whether that's correct or not. So usually, if you take the former attorneys' councils, they were appointed by the members. What is a good person to have? The senior Prof, who has now fled to Australia, was a chairperson of the Law Society of the Northern Provinces, highly respected until it transpired that he and his son stole about, I think they're talking about 100 million of funds that they overcharged and didn't pay out to their clients, etc. So, it's difficult to really come up with criteria to say it should be a fit and proper person. That's normally also why you have organizations like the Legal Practitioners Act now that allows people to elect and appoint, but you will find sometimes that people don't really know each other. They will vote for someone because they think they're in good standing, but it might later transpire that it's another Bobrov incident. So that is something that one can't really always control. You have to leave that a bit to chance. I was fortunate to be invited along by the Department of Health to go on a trip to the UK, which was paid for by the UK taxpayer. And we had several meetings with the National Health Service and their satellite bodies. They actually, they're the biggest health service in the world, but they have lots of little satellite bodies. They said a few years ago they actually took the National Health Service and sort of divided them up. And the NHS Litigation Authority, which they call themselves now NHS Resolution, is not a regulatory body. They try to resolve disputes as soon as possible, and they have the system that was referred to that the Office of Health Standards Compliance is now going to introduce, and I'm sure they got the idea there in the UK of adversarial incidents being reported as soon as possible and investigated, etc. So that's why I'm saying one has to determine what do you want this body to do. Because if it's something like the NHS resolution, it's not going to be a regulatory authority, because the functions will not fit. But that is something, hopefully, that the Law Reform Commission report or the process will be able to point out. I know we don't move fast because we have a long process of public consultation that we have to go through and we have to consider, and I've heard that I will be able to use all this inputs made here. But it's been a very valuable day. It's a Sunday and we all would like to do other things really, but I'm glad that I was invited and I really appreciate it. So these are all kinds of things, and one will have to come up with a motivation for what it is that you need and what you want that body to do. We cannot use an existing voluntary association because it's people that decide freely out of their own free will that they establishing this organization out of their own funds. I mean, they charge a membership. So if you give them legal standing, it's going to be a completely different process, because once you give something legal standing, you basically imply usually that government is going to fund it, unless you have something now like the Legal Practitioners Act, where there's funding from the that comes from the professions. So the funding is also a whole different kettle of fish. But I will look at all the proposals and hopefully come up with something.
Thank you very much, Ronel. That concludes the debate. Ronel ended the debate by asking a lot of questions. What do we want? So who are we? Which of us want what? And who's going to decide which of our different views is the view? So what I propose as far as that is concerned, this meeting is convened and called by SAMLA, but we are very fortunate in that experts outside SAMLA have agreed